Title to real estate is sacrosanct in terms of establishing a chain of title, a flawless chain of title. Usually what this requires is careful design and consideration of the trust, which requires legal advice, requires some thought and guidance.
So good morning, everyone. Today we have a special guest, Cristian Arrieta here. So Cristian, how are you today?
I'm excellent. Thank you. Thanks for having me.
Yeah. So first, just, introduce to our audience, say who you are, what would you do, and let's start from there.
Sure. Well, I'm a trust and estates attorney. I'm also managing partner of our local law firm here in Oxnard called Lothorpe Richards. As a trust and estates attorney, I help people with estate planning, also with probate, with trusts and estates administration. I help people with pretty much everything that touches an inheritance, and that also includes litigation.
Okay, wow. Yeah, that's really kind of like, in today's, typically when we're doing the escrow and the title transactions, I would like to hear more about how would you do that will affect our title and escrow service.
Sure. Well, what we're discussing essentially here is title to property. And I always like to say that title to real estate is sacrosanct in terms of establishing a chain of title, a flawless chain of title that goes all the way back to the beginning, goes all the way back to the state of California. Mm-hmm. And what we're dealing with title is with regard to an inheritance. One inherits property from their family, and there's going to be a process. The inheritance doesn't quite happen automatically. Uh-huh. It has to go through a process where title will transfer to those the heirs or the beneficiaries of a trust, and making sure that there's a proper chain of title so that they have clear title to their assets and are able to buy, sell, transact, loan, mm-hmm. borrow, etc.
Yeah, okay. So I just, since I have, a bunch of those international background, I do have a question, for you here. Is most likely when those people come to the U.S., and most likely it's their first time, typically I said from, China side, it's their first time to hear about the trust. So most of the time when they are in escrow, when people ask them, hey, so how are you going to hold, the title, the format, and then they hear about, also we can have a privilege to held in the family trust, but they do not have that yet. So what do you recommend to, when the agent's also doing them, what would you like to inform the agent to tell about the client to say, hey, maybe you should set up the trust first, or even during in the transaction, you still have the time to to set up a trust account.
Sure. And if a transaction typically takes, 30 to 45 days for the escrow to close, and it's early enough that the purchaser is considering formation of a trust, there would be sufficient time because what I'd like to point out there is that I've learned more than ever in my experience and in my practice that creation of a trust is never a one-size-fits-all situation. Yeah. There might be a whole lot of common elements for every family, but usually what this requires is careful design and consideration of the trust, which requires legal advice, requires some thought and guidance, and then documentation of how the estate is going to be structured mm-hmm. for themselves yeah. and for their loved ones. And so my process with estate planning can typically take 30, 45 days. So, okay. If you started right at the outset of escrow, it's feasible. Okay. Then again, really when you're discussing how title should be vested, seems like often enough that's a conversation is had closer to the end of escrow. Yeah. Mm-hmm. And so there, you wouldn't want to rush a very sensitive and unique trust for this family. You'd want to be careful and deliberate about it. Mm-hmm. And so there I would recommend that the purchaser can acquire title in their name as an individual or together with their spouse. By default, usually it's husband and wife as joint tenants. And then once escrow closes and title is vested, we can sit down with them and create a trust. And then we also handle transferring title to the assets to the trust, which is going to be one of the most important steps of creating a valid trust.
Yeah, okay, so that's very important. Now I just want to switch this topic a little bit. I know when we are doing the escrow recently, very, a special case.
Yeah.
So since, Galen is the one in charge of the 805 escrow, I would like you to share recently how we, handle the client's case and
Sure.
how we have the, Christian or, to help us
Sure.
with that case.
So we've had unfortunately, many transactions in which a property was owned by a trust. It was deeded out for a refinance. One of the spouses passes away, and the other spouse sometimes thought the property was still in the trust. Come to find out it's not. So now they're in a probate situation. So yeah, we've had people just blindsided and devastated. Now they don't know what to do, and they're told that it has to go to probate. So can you tell us a little bit of how you would handle that, help us handle that scenario as title and escrow?
Yeah, uh-huh.
And are there any alternatives?
Sure. Well, the start of that analysis is how is title presently held. They may have created a trust and properly titled their property in the name of the trust. Sometimes that too gets missed. Depends on the level of estate planning counsel they have.
Right.
Oftentimes there's, what we'd call a do-it-yourself trust or, document preparation service. And, importantly, they often leave out that last most necessary element of a valid trust is transferring the property. So that happens, but also when property has been titled in the name of the trust, and there's a refinance of the mortgage. During that process, the lender will ask that the property be removed from the trust, which another way of saying that has been revoked from the trust. So you've basically terminated the trust with regard to that asset.
Right.
And that way they can secure the mortgage the way they like to do it, where there's, a deed of trust or a mortgage placed on the property. And then now that that transaction's been completed and everybody seems happy, the purchaser has the owner has their new loan, the broker has completed his or her work on the project. Now they forget though to tell the homeowner, and you should put the property back in the trust.
Right. They think their job's done.
Yeah, they've kind of dropped the gauntlet and said mission accomplished.
Right.
But for the homeowner, they and unbeknownst to them, really,
Yeah.
their trust is no longer valid, and so now by default you're in a situation where, as you mentioned, one of the spouses has passed away, and then the second eventually goes, and the children now come to be disappointed to learn that they have to go to probate.
Right.
And that's the starting point. Is probate becomes necessary so that a judge can supervise the estate. It's proper accounting of the estate and distribution of the asset to the heirs or beneficiaries. Well, fortunately, there's a body of law that's developed around this sort of accident that tends to occur.
Right.
And it's called a Heggstad Petition. This refers to a family that dealt with this, I believe, back in the 1970s or 80s. The Heggstad family who had this very situation occur. And now there's another body of law that's applicable here called the Statute of Frauds, which means that you have to have a documented title transfer, written and dated and signed by the transferor to have any kind of valid transfer of real estate. So that's the Statute of Frauds that applies. Well, what we do as careful practitioners, as estate planning attorneys, is we create a schedule of trust assets that we append to the trust that identifies each of the assets that are being transferred, and it would include that real estate.
Right.
Well, a judge can take that and say, well, we have a written evidence and signed, by way of the trust that it is their intention to hold this property in the trust. Now we have a way to petition the court to go ahead and complete that transfer for us as intended.
Right.
That process can be relatively quick in comparison to probate. Probate may take 9 months to a year is typically what we estimate, whereas a petition, a Heggstad petition, could be set for hearing 30, 45 days out. And if we get all our ducks in order and don't have too many any sort of difficulty there or objections by people who might rear their head, then we can get a judge to grant the order. And so the situation you'd be finding yourself there in escrow and title is you've got a property under contract. There's an expectation that it's supposed to close on a certain date. Mm-hmm. Everyone needs to kind of hold their horses and be a little more patient so that someone like me can process this through the court. But it could create a delay of 30 to 60 days if we do it right.
Okay. And can you give us an idea of, you shared the time frames, kind of the difference between having to file the petition versus going through the probate process. Mm-hmm. What's the cost difference? Mm-hmm.
So, well, if you take the cost of probate is a formula, statutory formula that is based on the value of the asset. Mm-hmm. So, I can estimate, for example, that if it's about a $500,000 property, you'd be looking at probate fees of about $15,000 or $18,000 plus related costs. Sure. And so maybe your total budget there, your legal budget to complete probate is $20,000, whereas a Heggstad petition can be accomplished for about $5,000 to $10,000 maximum. And of course, we never know what's coming. There's sometimes
right.
You file something and someone else gets an attorney to oppose that.
Right.
Things can get dragged out, but that's typically the cost if there's no objection.
And is that a per property cost typically, or is this if there's 5 properties, let's say the family owned rental properties, right, and we find out there were several that were not held in the trust?
No, they can all be swept into the one hearing, assuming that it's all documented, as I mentioned before.
Sure. Okay.
Oftentimes that schedule of trust assets or the language, the magic language that we're looking for to help the judge give the necessary relief, for the situation, sometimes that's gone missing as well. But, if we have all the proper documentation, we can encompass numerous properties, other forms of assets, including investment accounts and the like.
Sure. Okay. Something else I'd like to touch on. How do you recommend investors go about putting their properties into the trust? Because there's multiple ways investors hold title. Let's say they have LLCs for each property. How do you recommend and how do you advise those investors to also be able to protect their assets for their family in the future?
Well, when you form an LLC around a rental property or other asset, the title to the real estate in this situation is ordinarily put into the name of the LLC. Mm-hmm. So the LLC owns the property. The owners of the LLC hold their membership interests in proportion to their shares, and their membership interest can be assigned by a simple document of one sentence. I hereby assign my interest in this LLC to my family trust.
Right.
And now you have the proper documentation to establish that.
Sure. Okay. Well, that's good advice for everybody.
That's a very good, advice. And then I just have an interesting, come up in my mind, normally, for your perspective, people under what situation they come, to you for your advice? Most likely, it's kind of
just in everyday life.
Yeah. Well, the smart ones come before there's a problem. I like to say, when we're doing estate planning, what are you doing really? You're putting your affairs in order, which is something that responsible people do before there's a crisis that necessitates some immediate legal attention. So that's one kind of client I get. Oftentimes, I'm getting a call from a panicked real estate agent or an escrow officer who's saying, we've got a property under contract that's supposed to close, next week. Yeah. And come to learn that our seller does not own the property. Yeah. Our seller told us he or she inherited the property, but inheritance of the, transfer of the title doesn't happen by osmosis. There has to be a documentation of that. And so, and in that situation, I'll help them open a probate immediately and get started on that. I like to tell the agents involved and the escrow service that the deal has not been spoiled. If everybody can be a little patient and amend their contract there's standard probate addendums that can be added to the typical real estate purchase agreement, and allow me to run the process through the probate court. A lot of people mistakenly believe that in order for them to close the sale, they have to close the probate. So they're scared that it's ruined. They're going to take a year to finish this. That's not the case. What'll happen is a petition for probate will come up for hearing in front of the judge 30, 45 days later. If everything's in order, the judge will grant the petition and open the probate and issue letters testamentary or letters of administration to the person in charge, the personal representative of the estate. That could be the executor or an administrator, depending on the context. As soon as those letters are issued, we can get the 15-day notice out to all of the heirs, which they can immediately consent, or if they don't object within 15 days, you can now close the sale. So you've only really delayed the close of sale in the range of 60 days instead of, the worst case scenario where you're worried it's going to be a year or something. So then title can, the escrow can close, title can transfer. The proceeds of that sale, though, have to be administered through the probate process.
Okay.
We help with that. But I guess the most important point there is you don't have to panic and figure that your sellers just breached a contract. If with a little bit of elbow room here, we can get the process completed and closed.
Yeah, very informative. So if people want to reach out to you, ask for help, how are they going to, do you have like phone number, social media, let people know how they're going to find you to ask for your help?
Sure. Well, yeah, you can. My phone number is 805-981-8555. We have a website, which is lrmmt.com. So I like to do that as Lima Richard Mary Tango.com. Yeah. So because we don't want people to find another law firm. No. We are on social media. Lothorpe Richards is on LinkedIn and I think Instagram. And I have a person that handles that. Galen knows him.
Oh, yeah.
Thank you. Yeah. So anything?
No, thank you for your time. We appreciate it.
I'm glad to be here. This was fun.
Yeah,
Thank you.
Thank you.